5 seconds to go. Start. According to him, the following points deserve consideration. Firstly, the quotes below fail to appreciate that none of the other persons present at the site of the occurrence, as per the version of PW2, were examined as prosecution witnesses. The courts ought to have inferred that had they been produced, they would not have supported the prosecution case and thus were deliberately withheld. Non examination of such independent witnesses, therefore, should be held to be fatal to the prosecution case. Secondly, having regard to the age of the appellant, he was 58 years old on the date of the incident. It is quite improbable that he could freely inflict stab injuries on the victim and the others without any one of the injured as well as the others present at the site even making an attempt to resist the appellant from inflicting injuries as also to save anyone of the others. Thirdly, it was necessary to establish by examining these independent witnesses that it was the appellant who came with the knife and holding it was on a stabbing spree, resulting in the death of the victim and injury to the others. Fourthly, all eyewitnesses PW2, PW3, and PW4 who deposed against the appellant were interested witnesses and therefore not credible, and their testimony ought not to have been relied upon. Fifthly, the courts below failed to take note that PW2 and PW3 were both interested witnesses and it was a clear case of false implication by suppressing the original story of the actual incident. Sixthly, it is surprising that although PW4 claimed to have snatched the knife from the appellant, there is no injury on his hand. On the contrary, there is no explanation from the side of the prosecution with regard to the 6 injuries suffered by the appellant. Seventhly, no motive could be established for the appellant to assault the victim and PW2 as the dispute between the parties arising out of unauthorized construction made by PW2 on the ground floor of the building of the appellant relates back to the year 2003. Seventhly, the knife was not recovered at the instance of the appellant under section 27 of the Indian Evidence Act 1872, but seizure has been shown to have been made at the site. There being contradictory statements of PW2 and PW4, it is unclear as to who introduced the knife in the scuffle. Finally, the appellant was a permanent resident of Nagpur, whereas the place of the incident is Katol, a tehsil place situated about 50 kilometers from Nagpur. There could hardly be any reason for the appellant to travel such distance and murder the victim, and that too with a knife in broad daylight and in the presence of a host of people. The second limb of the arguments of learned counsel is that even if it be assumed that death of the victim occasioned at the hands of the appellant as per the prosecution case, The victim was initially away from the place of incident and was the last to join the scuffle. There was thus no premeditation on the part of the appellant as such, and the victim seems to have got injured unintentionally in the scuffle between the appellant on the one side and the victim PWs 2, 3 and 4 on the other. Therefore, clearly the victim was not the target. He contended that conviction of the appellant under section 302 IPC was erroneous on facts and in the circumstances, and that the evidence at best made out a case punishable under section 304 part 2nd IPC. The appellant has been behind bars for 9 years, and it is only fair, just, and proper that this court, upon consideration of the materials on record, directs his release. Stop.